Good afternoon. I am Jean-Christophe DUHAMEL from the Lille Law Faculty in the north of France. I would like to address the issue of the circulation of images from a legal point of view. My presentation is precisely entitled From the Control of Visual Content to the Control of the Circulation of Visual Content, a description of legal evolution in a digital universe. The digital age is reenacting the role that the appearance of photography played in its time. Here are disruptive technologies leading to new uses which foster the law to evolve. The digital age is disruptive because of the ease with which images can be caught, combined with the power and speed of networks. The result is a huge capacity of spatial-temporal circulation of images. Images now occupy an immaterial territory which is emancipated both from the frontier forged by history, languages, culture, but also from time, as shown by the instantaneous data transfer. The call for paper was asking, what does circulation do to an image? The law, in its own way, provides a clear answer. Circulation can make the image illicit, even though its content would not be illicit. And it seems that the digital age is making this phenomenon even more acute due to visual practices of the internet users. Basically, there is a kind of renewal of transformation of the legal paradigm in visual matter, which is moving from the regulation of visual content to the regulation of the circulation of visual content. The legal fields concerned about such an evolution are numerous, and each one responds to its own logic. So I must resolve myself to a kind of conceptual modesty, and I will avoid to elaborate a general legal visual theory. Assuming this position, legal visual studies, when they are conducted by a jurist, lead to a case study much more than to a conceptual approach. Hence, I propose to identify what seem to me to be the main areas of law today that are reacting to the circulation of images in the digital universe. First, the right of privacy. Second, the intellectual property. And third, the freedom of information. At the end of my presentation, I will propose some thoughts about the circulation of images for the future with regard to which the law is, in my opinion, rather designed today. So let's begin with the first point, images and right of privacy. It's important to remind that in Western societies, law does not regulate private practices as long as they are freely consented and do not harm third parties. This rule can be transposed to privacy photographs and videotapes. With the rise of internet, social networks, and universal access to video recording, the subject of sex tapes and revenge porn has become, of course, the focus of attention in terms of privacy. In France, the first major case occurred with the swimming champion Laure Manodou, who was a victim of non-consensual disclosure of intimate photographs. But very recently, just a few months ago, we have seen that such videotapes could have a major political impact in the context of the Paris local elections. The visual content shared by two consenting persons did not entail any problem in law, but the circulation of this content did. The leak was set up by a Russian artist, Piotr Pawlensky, who claims to take part in a political porn movement targeting, I quote, civil servants and political representatives who lie to their voters by imposing puritanism in society, even so they themselves hold it in contempt. The French Parliament has recently reacted by adopting a law in 2016 specifically devoted to the revenge porn. This law expressly incriminates, I quote again, in the absence of the person's agreement to the release, the act of bringing the attention of the public or a third party, any recording or document containing words or images of a sexual nature obtained with the express or presumed consent of the person or by himself. Sometimes the circulation of images of privacy has legal consequences, even though their content is lawful and the person concerned is at the origin of the circulation. This is the Julie Brixman case, which did not give rise to litigation, but had legal fallout. At the end of October 2017, Julie Brixman rides her bike, as she usually does at the weekend, and gets passed by the United States President's convoy leaving Trump National Golf Club. Spontaneously, the cyclist flips the president off. The gesture was captured by the professional photographer Brendan Snialowski, and I can share my screen to show you the litigious photo. Okay, it's a well-known image. So a few hours later, the image was posted online and became rapidly, of course, viral. Julie Brixman was not aware that she had been photographed, but even though she was not recognizable because she was shot from behind, she decided to promote her behavior, gesture, by making it the profile image of her various accounts on social networks. Her employer, for whom she worked as a marketing manager and who had contracts with the army and the US government, decided to dismiss her. From a legal point of view, the content of the photograph does not really constitute a problem in the United States. Was the First Amendment protects freedom of expression, even when it takes inelegant and provocative forms. In France too, the specific offense of insulting the President of the Republic has been abolished in 2013, even if there are still more restrictions on public insults compared to the US. But anyway, the real problem here was, therefore, once again, not the visual content as such, but its circulation, which had a negative impact on the image of Julie Brixman employer. Labor law in the United States is obviously more liberal and flexible than in France, and the dismissal was valid from a US legal point of view. But in France, in similar circumstances, dismissal is only valid if the privacy images posted on social networks cause an, I quote, objective disturbance to the company, to the employer. And the employer must prove it. And if it succeeds in doing so, this means that the circulation of the image will have transformed it into an objective and valid justification for legal breach of the employment contract. The second field of law challenged by the circulation of images is, in my opinion, intellectual property. The circulation of images in the digital age has given rise to many specific problems with regard to the protection of the intellectual property. For an obvious reason, copyright contains two aspects, namely the right of representation to the public and the right to copy for the purpose of representation to the public. Actually, with the advent of digital technologies, copying and representation have never been easier than today. In that respect, digital technologies could appear as an optimal tool for copyright infringement, especially when these rights concern image. I would just like to refer to a recent and important case law ruled by the Court of Justice of the European Union in 2018. So what was the case? A young German pupil had to do homework on Spain and decided to copy and paste an image of the city of Cordoba she had found on the internet. It was a photo taken by the German photographer Dirk Renkoff. You can see it here. This is the litigious photo. The work the girl had done was so good that the school published it on its website. Dirk Renkoff decided to sue the German Education Authority for copyright infringement. He argued that no permission had been given by him and that the school had not paid any copyright fees. This procedure is very complex, but to sum up, the Court of Justice of the European Union stated that at the European Union level, the copying of an original creation fully accessible online for the purpose of publication on another website is prohibited if the author has not given his approval. This decision adds to a previous ruling in 2014, which had allowed copying and pasting of hyperlinks and only hyperlinks to original works fully accessible online. But the situations can be more specific, due, for example, to an image that circulates, especially online, which can contain an original creation protected by intellectual property rights. Here, the creation is not the image, but something contained in the image. The issue of the panorama exception is concerned here, namely the question of images taken in public areas that contain works protected by copyright, such as sculpture or architectural work. I've got an example here. This is a creation, an original creation by Anish Kapoor in 2015, located in the park of Versailles Castle. And you can see that there's just an original creation protected in the picture, but the picture is not as well protected by itself. We could spend 1 hour just on this point, but I will only give you the following current position of French law, which is in line with the European regulatory framework. Since 2016 in France, the law states, I quote, "When the original work has been disclosed, the author cannot prohibit reproductions or representations of architectural works and sculpture permanently located in the public area to the exclusion of any commercial use." French law, therefore, allows the free circulation of images, including on the internet, of sculptures or architecture in the public area, even though they are protected by copyright. But 2 important conditions must be respected. First one, no commercial use, and the second one, this does not concern works placed temporarily in the public area. It therefore does not apply to temporary exhibition, such as Anish Kapoor one, as we have seen in 2015 at Versailles. Now I would like to address the freedom of information as the third field of law concerned by digital uses and the circulation of images. Freedom of information is a legal principle which in many countries has a constitutional value as it derives from freedom of expression. This freedom is embodied in the free circulation of images with the aim of informing. However, this goal is sometimes in contradiction with the individual freedoms and fundamental rights of the person concerned by these circulating images. Here, each country may have a specific legal approach. For instance, there's a real gap between France and the USA concerning this issue. Let's take two examples of such images that pose a legal problem in France. First, France woke up in shock on 15 May 2011. The image of Dominique Strauss-Kahn, the likely ex-future president of the French Republic, handcuffed and guarded by two New York police officers, was circulating all around the world. I can show you this picture here. It's a very, very well-known image, of course. 2 days after, the French media regulator issued a directive to the French media asking them to stop broadcasting these images, a request that may seem totally outdated and incongruous in the age of internet and the global circulation of information. However, the French media regulator was merely applying a law of 2000, which prohibits the release of images of people being shackled, both to preserve the dignity of the person and the presumption of innocence. Here again, this is a perfect legal example which makes it possible to understand that it is not the photograph itself, namely the visual content, that is incriminated, but the sole fact that this content can circulate. An image becomes illegal because it circulates. The French penal text is indeed very clear because it targets the diffusion and only the diffusion without the consent of the person concerned and by any means of the image of an identified or identifiable person who is the subject of criminal proceedings but who has not been convicted yet and who appears either to be wearing handcuffs or shackles or to be in a pre-trial detention. The second and the last example is the denunciation of offenses by image. Today, the democratization and miniaturization of recording devices leads to a general monitoring of everyone by everyone. Offenses are subjected to denunciation through images via the powerful channels of social networks. For example, an interesting case occurred in April 2016 in France, where a dentist's professional bag was stolen in a waiting room. The scene was filmed by a small camera placed in the waiting room, and the dentist immediately decided to post the images of the offense on Facebook. The goal was to, of course, identify the thief. But the thief decided to sue the dentist, in particular for an infringement of the presumption of innocence. The prosecutor decided not to prosecute the dentist, and only the thief was convicted. This decision of the public prosecutor's office is open to criticism under French law, because the respect of the presumption of innocence has a constitutional value. The violation of this principle is a matter of defamation, and courts in France traditionally hold that it consists in publicly presented as guilty before conviction a person prosecuted under criminal law. The circulation of images via online social networks aimed at denouncing an identifiable offender in France therefore constitute a violation of the presumption of innocence. To conclude, we've seen that in many areas of law, the internet and more generally the digital age has intensified legal criticism of images, not because of their content, but because of the circulation of their content. This movement is far from over, because growing technologies will easily make it possible to circulate in the near future, if this is not already the case, images whose circulation could be very, very disastrous. The legal regulation of the circulation of images will have to be sought through much more ambition, so as to protect people from, for instance, mass manipulation. In particular, we are thinking here of the deepfake generated by artificial intelligence. For example, Barack Obama's deepfake in 2018 has created a lot of discussion and worries, but we can be skeptical about the capacity of state law to react, and the involvement of private actors, namely managers of social networks, will be essential here, even if at the same time this private actors' supervision will make such a regulation undemocratic and subject to doubt. Here it is finished. Thank you very much for having paid attention to this presentation. Bye.